On January 5, James Edward McClinist, a longtime advocate for police accountability and a former candidate for sheriff in Penless County, was walking along a quiet residential stretch of 129th Street in Florida while recording video of several unmarked law enforcement vehicles lined up along the road, which he believed were part of an undercover operation. Nearby deputies from the Penless County Sheriff Office, who were busy with an active investigation, quickly noticed his presence and began to pay close attention to his actions. What happened next unfolded in real time and was fully recorded on an officer body camera, offering a clear view of the encounter as it developed moment by moment in the
29th Street. We've got multiple undercover police vehicles with regular license plates on it. All of them left running. See, notice the police laptop in that one. Again, this one's got a fake license plate tag on it, darked out windows, but it too is also running. And notice it has police laptops and police equipment in it as well. And then this is another police pickup truck, also running. And again, with police inside the vehicle. Just all the undercover police cars. Police sheriffs at this house, undercover.
I don't know, take a video of
And,
tags and stuff like that.
and this one here does not look like a police vehicle.
What exactly are you doing? Just curious.
Just taking video.
Well, you're doing that is any purpose. Just asking.
It's a First Amendment protected activity.
What's that?
It's a First Amendment protected activity.
Hey, sir. You know what else says that? ID on you?
I don't need ID.
Yes, you do need ID.
No, I don't need to ID.
If you're coming into the middle of our investigation, you do.
Actually, this is the middle of the street, and I'm
And
walking
you're
on a
not
public
supposed
street.
to be in the middle of the street, so that's a violation.
Actually, there's no sidewalks here, so it's not.
You cannot be in the middle of the street.
Well, you notice you're blocking the way on the side of the street.
All right, let me get a pad. You have ID at all?
I don't have to show ID. I have not committed a crime.
Did you drive here?
No,
But you have to ID who you are.
no, I don't.
Yes, you do.
Under Florida statutes, we're not an ID upon demand state. Am I being detained?
I said I was getting my notepad.
Hey. Are you writing him a ticket? You do understand when there's not a sidewalk, there's a certain direction that you need to write. You need to walk on the street, right? You can't just walk down the middle.
Well, when you have all the cars blocking the side of the road, it makes it kind of difficult.
Okay, well, guess what, Perry Mason? Since you're so good on the
What's-
First
are
Amendment
you a
and the
police officer?
Constitution and all that,
I'm asking you to
read the
identify yourself.
statutes. Excuse me?
I'm asking you to identify yourself. Are you a police officer?
Yes, I am.
Can you please give me your name and badge number?
No.
Are you refusing to identify yourself?
What, is there a Florida state statute that says I must?
I think it's are you a Pinellas County Sheriff?
Yes, I am.
Well, isn't it a Pinellas County Sheriff general order that when a citizen asks you to identify yourself as an officer? What if I want to file a complaint against you? How am I supposed to be able to do
Then
that?
you'll get it.
How am I supposed to file a complaint against you?
Okay. What do you want to file a complaint
No.
for?
this opening exchange to legal.
Practical in this situation, the deputy's own vehicles were blocking part of the roadway while the opposite side remained open, creating a narrow but genuine argument that McClinist may have been in technical violation of a minor non-criminal pedestrian rule. Even so, the second issue is more clear, and the officer position does not hold under the law. Florida Stop and Identify Statute Section 901-151 allows officers to request identification only when there is reasonable suspicion of a criminal act or an imminent criminal violation. Walking in the roadway is treated as a civil traffic matter, not a crime, which means the deputies had no legal basis to demand identification. His refusal was not resistance, it was a lawful choice. A's for
Okay, but let me finish my train of thought
Go
first
ahead.
before you interrupted me with all your Perry Mason stuff. Do you understand that there is a Florida state statute against walking in the middle of the roadway?
Which is what you
Do you
just
understand
did.
that?
When I come out of
It's a yes or no
What-
question.
Sir, do you understand
I-
the question that's
you
been
have-
asked of you?
you have the
Do you understand
you
the
have the
question
street
that's been
blocked.
asked of you? Sir, the street is
You
not
have the street
blocked.
blocked.
The street
Yes.
is not blocked.
Yes.
You walk past actual vehicles that are here.
Yes.
You just drove by us. How are we blocking you?
Exactly.
You
I
are
guess
blocking
that
the
pretty much answers your
pathway on the
question,
side of
doesn't
the on the side of the road. This is the intimidation that the Pinellas County Sheriffs try and use if you exercise your First Amendment activity.
No,
They surround
actually-
you, accuse you of crimes, refuse to identify
not a
themselves,
crime, it's a
intimidate
civil
yourself.
infraction.
Why aren't you continuing with your investigation? Why are you out here bothering me? I walk by with my camera,
Because you
videotape.
committed a civil infraction in front of me. You got a problem with that?
There is no civil infraction. You're blocking the road.
I just explained to you what you did. Walking in the middle of the road is a pedestrian violation.
And when you have the side of the road blocked and there are no sidewalks here, it's not a pedestrian violation. But nice try.
You're right. You're the expert. You know, I've only spent 20 years doing this job. You're the expert, though, right?
After 20 years, you still
What
think it's
exactly
necessary?
statute is it? Do you know
After
what
20
statute
after
it is?
20 years, you think it's actually necessary to come out in the street and bother people who are walking by?
You can't walk in the middle of the road.
And when you have the street blocked,
Street's
the
not
side
blocked.
of the side of the road blocked,
Street's not blocked.
you have the side of the road blocked.
The street's not blocked.
Sir,
Yeah.
Street's not
shine,
blocked.
shine your phone that way because I want to make sure that you see this as well, that this is on video.
Yeah, I'll shine the phone.
So from here all the way through, past the area that you actually walk through, the street is not blocked.
This
The
side of the street
vehicles
is
are on the
blocked.
curb, but you actually walk. So how is that actually blocking
This side of the street
streets?
is blocked.
Okay.
And there's no sidewalks here.
So here's the thing right now. This is what I would tell you. We have an investigation that we're
I see
working
that.
on here right now, and you're impeding that investigation. So is
Actually-
there anything
actually-
else you would like to talk
Actually,
about?
by walking down the middle of the street and
Is there
conducting a
anything
First
else that you
Amendment
would like to
activity,
talk about? Is there anything else you would like
I
to
didn't
talk
want
about?
to talk to you, any of you, in the first place.
Have a good day, sir.
Thank you. I appreciate it.
You can leave now.
Thank you. Appreciate it. I still can't walk down this side of the street,
And told you to leave. Leave now.
so I have to leave the street.
Leave this investigation right now.
So where is the investigation? Where's the blue line? Is it over here? Is it over here? Is it over here?
The claim that Linist was impeding an investigation stands as the weakest legal point in the entire encounter. Florida law does address obstruction under Section 84302, which defines it as a first-degree misdemeanor to resist, obstruct, or oppose an officer carrying out a lawful duty without violence, yet courts have consistently clarified how limited that definition is in real situations. In the 1995 case DG versus State, the Second District Court of Appeal ruled that when a person is not being legally detained, is not subject to a warrant process, and has not been asked to assist in a serious emergency, then speech alone almost never qualifies as obstruction. Linist was not detained. He was not lawfully identified. While beginning to comply with an order, to move does not create probable cause for an obstruction charge. There is simply no reasonable interpretation where walking on a public street holding a camera, requesting a badge number, and referencing statutes becomes criminal obstruction. That allegation had no foundation when it was made and remains unsupported under every relevant legal standard. From the moment deputies approached McClintis, their performance reflected a serious misunderstanding of the laws they claim to enforce. Demanding identification over a non-criminal pedestrian matter was not permitted under Section 9. No support under Section 84302 or any court ruling.
Identities in the Supreme Court in cases such as Hoffa versus United States in 1966 and Illinois versus Perkins in 1990 has recognized that deception during investigations can be lawful, yet there is a clear distinction between protecting an undercover role and refusing to provide basic identifying information needed for accountability. The situation creates a real dilemma. Without a name, there can be no complaint, and without a complaint, there can be no oversight. The tone of the interaction remained dismissive and escalating, which only worsened an already flawed encounter and reflected poorly on a department that can least afford further erosion of trust based on prior documented tensions. McClintis the obstruction claim as legally unfounded. He later attempted to follow proper complaint channels, even when those avenues were limited by public records exemptions under Section 11907. The only factor preventing a perfect assessment is that he could have positioned himself on the opposite side or left shoulder and still captured the same events without giving officers even a minor argument regarding a pedestrian issue. His conduct overall remained disciplined and effective, though his position gave officers a small opening that could have been avoided. Let us know if there is another legal interaction you would like examined in the comments, and thank you for watching while continuing to support Legal Logic for clear analysis.